In this video, I'd be speaking about parallel imports, and we would be specifically discussing the legality of parallel imports with respect to the trademark law in India. So let's understand what do we mean by parallel imports with respect to a particular example or an instance as mentioned here. So, for example, if you speak about a product A, right? So, a product A is priced at $60 in Nepal, right? Uh, and due to certain different taxation regimes or various factors being involved, there is a difference in between the price that is there in Nepal and that is there in India, right? So due to market trends or due to subsidies, due to different taxation regimes, that particular product is placed at $60 in Nepal, and the same product is placed at $80 in India. So now, uh, what is parallel import? So now, this product which is priced at $60 in Nepal is now imported into India and is sold for $70 in India, whereas the actual right holder of the product has priced the same product at $80 for the Indian market. In this particular scenario, what we can see is that the consumers in this case are getting two products of the same brand, right? These are the same products of the same brand, but they are priced differently, right? So there are two parallel channels turning out, right, in this particular case, and one is ought to be cheaper, right, because they are imported from a different country. So there are two parallel channels for the same product, right, for the same product, but it is placed at different prices. So if you see over here, parallel import occurs when goods belong to right holders, are legitimately acquired, right? They're legitimately acquired or bought by a third party in country A, right? And are then imported to and sold in country B without the express consent of the right holders. For example, if we are talking about this product A is having a trademark of company C, right? If product A is having a trademark of company C, so company C is the actual owner of it, the trademark owner of it, right? Who is owning the trademark over product A, right? So now this trademark owner has already sold it in the market. He's already sold it in the market. So there is a first sale doctrine that is applicable in this case, that after you have sold it in the market, you have exhausted your rights, right, over it being sold continuously in the market, over it evolving in the market now, right, over it actually revolving in the market. So now in this particular scenario, when you have already sold the product A, C is the one who is owning a trademark over it, right? He has sold it in the market. Now this product can be bought by anybody, right? It can be bought by anybody in the market, and that person is actually legitimately acquiring it. He is legitimately acquiring it, right? By it is acquired by a third party, and that person is now selling it in a different country. So for example, if we talk about a particular product of Samsung, so a Samsung product that is being placed at a cheaper price in Nepal, right? A Samsung product. So now there is a registered proprietor of it who has bought it from Nepal, and he is now importing it to India, and he is selling it at a cheaper rate than Samsung has actually placed it in India, right? Samsung has placed it at $80 in India, but because this registered proprietor, this particular person who has authorizedly bought it in Nepal, he has the capacity to sell it at a cheaper price in India because he has gotten it from Nepal where it is sold at a more cheaper price, right? So this person over here, the third party who is buying it from Nepal and selling it in India, he is actually having a profit, right? He's selling it at $10 more, right? But here in this scenario, indirectly Samsung is facing a disadvantage. Why? Because there is the same product that is sold by Samsung in India at $80, whereas a cheaper product of the same brand is already available in the market, right? So that is something which is affecting the original trademark owner. So now let's understand whether this whole process, on the basis of first sale doctrine, on the basis of exhaustion of rights, whether that falls within the boundaries of legality, right? So let's understand whether this whole process that I have explained over here of parallel importations of two parallel channels running due to this particular transaction that is happening over here, let's understand the legality of this transaction. The definition of parallel imports. To define parallel imports, we can say that parallel importation refers to the act of purchasing trademarked or patented goods sold legally in one country and exporting the same to another country for resale, usually for a price lower than that is prevalent in the importing country. The ability to sell such goods at a lower price in the importing country may arise due to fluctuation in currencies or due to different distribution channels. Parallelly imported goods are often confused with counterfeit items, but these are not the same, right? So counterfeit goods are entirely different kind of goods per se. Counterfeit goods are the ones which are containing a trademark or a particular logo that is identical or substantially indistinguishable from the trademark of another. So these are completely different kind of products altogether. Parallel imports are legitimate goods. These are legally sold goods in one country which are imported into another country, right? So these are legally sold goods. The only principle that we need to understand is whether what is the principle of exhaustion, what is the exhaustion of rights that is given or that is applicable in a particular country, right? Whether the trademark rights, when does a particular person exhaust his exclusive rights that are applicable over a trademarked or a patented good. That is what we need to identify and understand while we understand the legality of parallel imports, right? Remember that parallel imports are particularly legally, these are legitimate goods, right? So these are legitimate goods. That is the particular essence of parallel imports. Parallel importation is essentially a trade practice and therefore it is regulated by both intellectual property law and competition law. In the trademark law context, parallel importation significantly affects the right of a manufacturer or trader, as trademarks help traders earn goodwill in the market and to protect their commercial reputation. Uh, there are certain territorial rights that are attached to a particular trademark, right? It indicates the source of the trademark product or services, and therefore a conflict arises when parallel importation results in a misrepresentation of the source, reputation, or the quality of the trademark good. So in simple words, you can refer parallel imports as grey market goods because these are goods which are genuine but they are sold through unauthorized trade channels, right? These are sold from one country to another country. These are genuine goods which are acquired from one country and are sold to another country without the permission of the intellectual property owner, right? The products are indeed legal but are unauthorized because they are imported without the permission of the proprietor, right? So now let's understand the very intricacies of market, right? What do we mean by the doctrine of first sale, and let's understand whether these doctrines actually apply in case of trademarked or patented goods or not. So let's understand doctrine of exhaustion. So doctrine of exhaustion essentially means that an owner of a particular good ceases to have control over further sale of his goods once he has already made a valid transaction of sale, right? So for example, if there is a trademark owner, right, if once uh, let's consider let's consider the trademark Samsung. So once Samsung product are sold, essentially put on the market by the owner, right? Once Samsung trademark goods are essentially put on the market by the owner, right, or by his consent, right, and once they are legitimately purchased by one party, right, then in this scenario the trademark owner, right, as in Samsung, originally Samsung, uh, or any other person who is deriving his title from Samsung Incorporation, right? So they cannot prevent further sale of that good, right, which has essentially been sold in the market already. And this is, right, this is called the doctrine of exhaustion, right? uh, so the exclusive right to sell goods bearing the mark is exhausted by the first sale, right? And the exclusive right to sell goods bearing the mark cannot be exercised twice in respect of the same good, right? And that is why this is called the doctrine of first sale. So there is an exhaustion of the right of the trademark owner according to the doctrine of first sale, right? Because once the trademark owner has already put his goods in the market, once Samsung Incorporation has already put the goods in the market, then he does not have a control over where these goods are going to go. Once you have sold them in the market, there is the doctrine of first sale applicable, and there is an exhaustion of rights of the trademark owner over his own goods, right? So now there are different principles of exhaustion which actually determine these levels, right? There are certain levels within which you determine when a particular trademark owner's rights are exhausted, right? So the principle of exhaustion followed by a country determines such country's threshold at which the exclusive right of the intellectual property right holder over a product is exhausted. So let's understand the doctrine of exhaustion first. So there are three kind of doctrine of exhaustion. There are three levels of exhaustion, three modes of exhaustion that have been recognized internationally. So this doctrine of exhaustion that is followed by a country actually determines the right of the trademark holder, right? So Article 6 of TRIPS, Trade Related Aspects of Intellectual Property Rights 1995, read with footnote 6 of Article 28 and Article 5 Clause D of Doha Declaration, provides its signatories with the right to determine the principle of exhaustion they want to follow. Let's understand how does doctrine of exhaustion apply to the right of a trademark holder in this particular case. Understand what is a particular different kind, or what are the different models of exhaustion, principle of exhaustion that are there. The first model of exhaustion is no exhaustion at all. According to the principle of no exhaustion, the right of the right holders on intellectual property does not exhaust at any point. So if a particular country follows the doctrine of no exhaustion, then the doctrine of first sale is also not applicable, right? So whenever a particular right holder has sold it in the market, sold a particular product in the market, he has a control over where that intellectual property would go, right? So his rights of resale is still intact in this particular scenario if principle of no exhaustion is followed. Next, there is the case of national exhaustion. As per the doctrine of national exhaustion, the buyer of an article bearing intellectual property can lawfully resell or transfer the same within the country itself. Such resale or transfer within the country without the permission of the right holder would not amount to infringement, since the right holder has exhausted his rights to the goods within the nation upon the first sale of goods. However, the right holder's intellectual property right would revive once the goods are exported to different country. The buyer does not have the right to resell the goods in a different country without the permission of the right holder. So apply the doctrine of national exhaustion to the instance that we discussed earlier, right? In Nepal, it is sold at $60 each, right? The product A is sold at $60 each. The national exhaustion principle says that the doctrine of first sale is only applicable in that country per se. As in, once Samsung has sold a product by virtue of a registered proprietor in Nepal, it can be resold in Nepal to any other person, right? But it cannot cross the border, because there the IP rights would again revive. So the IP rights are exhausted within the limitation of the nationality, within the limitation of the country itself, right? In the country, it can be resold to anybody, and there the trademark owner has no right over controlling where will the product go within the country itself. But the moment it crosses the boundary, the IP rights evolve again. So that is the principle of national exhaustion. So if Nepal follows the principle of national exhaustion and the product is trademarked in Nepal, then nobody can buy it in Nepal and send it to India per se, because that is not allowed under the principle of national exhaustion, right? So there the IP rights are revived again in this particular scenario. Then is the principle of regional exhaustion. As per this doctrine, the buyer of an article bearing IP, intellectual property, can lawfully resell or transfer the same within the countries belonging to a specific region. In this case, the right holder exhausts his rights in all countries belonging to a region by putting the goods in the market of any one of the countries of such region. For example, European Union, right? However, the buyers cannot resell the same in a country outside the region, since the right holder's IP right would revive once the goods are exported to a country outside the region, right? The European Union follows the doctrine of regional exhaustion. So the IP rights are exhausted within that particular region per se. So outside the European Union, you cannot sell it without the permission of the IP owner, right? So the doctrine of exhaustion over here is regional exhaustion. Regionally, the rights are exhausted, but the moment it crosses that region, the IP owner's rights are evolved again, right? And then lastly, there is the principle of international exhaustion, where it is stated that the moment the goods are put in the market anywhere in the world, the right holder's IP rights in relation to such goods are exhausted, right? So whenever you put it in the market, whether you put it in Nepal, whether you put it in India, the rights of IP owner are exhausted. And then if international exhaustion principle is applicable to the first scenario, the first instance in Nepal, if international exhaustion is applicable in India and in Nepal, then there is no such restriction over a person buying a legitimate good in Nepal and then importing it in India, right? That is legally allowed if principle of international exhaustion is followed in both the countries, right? So now this principle, this doctrine of exhaustion, which is adopted by a country, that determines the right and the boundaries of rights of a particular IP owner. So now let's understand the legality of parallel imports in India. What does the Indian law, the Indian Trademark Act, the Trademark Act 1999 state about parallel importation and the kind of market that it has, right? Whether it is following the world market, whether it is following the concept of international exhaustion, whether it is following the concept of regional exhaustion, or whether it is following the principle of national exhaustion. So let's understand the kind of of market that India has adopted, and the kind in which India has limited the rights of the trademark or patent trademark owners, right? How it has limited the rights of its own intellectual property owners. Section 30, clause 3 states that whether goods bearing a registered trademark are lawfully acquired by a person, the sale of the goods in the market or otherwise dealing in those goods by that person or by a person claiming under or through him is not infringement of trade by reason only of the registered trademark having been assigned by the registered proprietor to some other person after the acquisition of those goods, or the goods having been put in the market under the registered trademark by the proprietor or with his consent. So we can see over here that section 30 deals with the limit on the effect of a registered trademark. The subclause 3 prevents the trademark owner from prohibiting the sale of goods in a geographical area on grounds of trademark rights once three goods under the registered trademark are lawfully acquired by another person. Subsection 4 then goes on to state that subsection 3 shall not apply when the condition of goods is changed or impaired or they have been put on the market. What you can see over here is that the term market has not been essentially defined over here, right? So we cannot really understand from the particular section whether they are referring to a particular national market or to a international market or a regional market. That is something which is left to be understood, right? So this problem of understanding the kind of market that is embodied in the Trademark Act, this issue of whether the Indian Trademark Act 1999 embodies the international exhaustion principle or national exhaustion principle when the registered proprietor of trademark places the goods in the market under registered trademark, that particular dilemma whether the market is applying the national exhaustion principle or the regional exhaustion or the international exhaustion principle was something which was yet to be determined. And this question was put up in the case of Kapil Wadhwa versus Samsung Electronics. So as you can see here, we have particularly in this slide, we have been talking about section 30 clause 3 and section 30 clause 4 again. So the first part is particularly talking about section 30 clause 4. It says that the section deals with the exhaustion of trademark rights of the right holder after the first sale of goods. It states that dealing with goods after the sale of a right holder would not constitute infringement as long as the goods are not tampered with after the same has been put on the market, right? It is important to note that this section deals with the rights of the registered proprietor, that is the right holder who has a registered trademark in India. However, the Act does not clarify the meaning of the term market, as I said earlier as well, that there is a particular ambiguity with respect to the understanding of market, right? Whether the doctrine of international exhaustion is applicable, whether the doctrine of national exhaustion is applicable, right? So there is an ambiguity with respect to it. The ambit of the term market used in the section will determine whether India follows the doctrine of national exhaustion or the doctrine of international exhaustion. In other words, if the market in this section refers to domestic market of India, then the doctrine of national exhaustion would apply. And if it refers to international or global market, then the doctrine of international exhaustion would apply. And as I stated in the last slide as well, this particular term, the interpretation of the term market, this arose in the case of Samsung versus Kapil Wadhwa, where the courts tried to understand whether we have doctrine of international exhaustion or do we have doctrine of national exhaustion. So in October 2012, the term market used in this section under section 30 clause 3 was interpreted by a division bench of Delhi High Court, and it said that it was meant to be a global market. And in the case of Kapil Wadhwa versus Samsung Electronics, it was held that um, but there is the international theory of exhaustion that is applicable in India. It validated the international exhaustion principle. However, the only condition imposed by the court on parallel import was that in relation to trademark, uh, the imported goods should state that they have been imported, and that after sales services or warranty is not provided by the right holder and rather by the buyer. So let's understand why this particular term was mentioned by the court per se. So for example, in this case, particularly Samsung versus Kapil Wadhwa, what happened was that when a person when this person was importing the goods from another country and selling it in India, people who would be buying it thinking that it is the same product but at a cheaper rate it is available, right? They would be buying it from this third person, right, who is buying it from another country and selling it in India, right? They would think that the after sales services would be available, would be given by the registered proprietor, and the registered proprietor fails to do so, right, in this scenario, because the registered proprietor in India is not selling those products, right? For example, if in this case Samsung products are bought from Nepal and then they are sold in India at a cheaper rate, the products are somehow belonging to Samsung, but the after sales services cannot be given by the registered proprietor in India per se, because they are not the ones selling it, right? So here what happens is, even though the fault is not of the registered proprietor, right, it is happening due to the loophole that is there in the system per se, right? It is not because of the fault of the registered proprietor, but still there is a certain amount of disrepute that is occurring to the particular trademark owner, because there people in the market who are buying it for a cheaper rate, they are thinking that the after sales services are not good, right? They're not providing good maintenance services, good after sales services, so that is not available in that particular scenario. So the court particularly mentions that due to this disrepute that was occurring, to completely curb that situation, to rectify that situation, it was necessary that it should be mentioned by the person selling it in India, because they have held that it is a global market and the principle of international exhaustion is applicable, that once it is sold in the market, it can be sold anywhere in India or in any other country with regard to the principle of international exhaustion, right? So because it is the global market, they can sell it anywhere without the permission of the IP owner, right? But the only condition is that they have to particularly mention that these goods are these are imported goods, and after sales services and warranty is not to be provided by the right holder, and rather it has to be provided by the buyer. So here the registered proprietor in India is not responsible for after sales services and warranty, right? So that is something which is applicable in this particular scenario. Samsung has appealed against the judgment of the Delhi High Court in this case before the Supreme Court of India. The Supreme Court is hence now seized with the task of deciding the legality of parallel imports and on whether the Indian Trademark Law recognizes the doctrine of international exhaustion or national exhaustion. So what you understand from this particular case is that till now India is following the doctrine of international exhaustion, and the market rights that are provided to the IP holder is in accordance to the doctrine of first sale, that once you have already sold a product in the market, your rights are completely exhausted over that product being resold, right? So that is the principle that is applicable in India. All right, so that is about parallel imports. If you have any doubts, you can email them to me, and we'll discuss about them there. Thank you so much.